Hello, my dear friends. Welcome to Hari Shewa IBBI Valuation Cracker YouTube channel. My name is Rajesh S. Wadhwani. I am a civil engineer and IBBI register valuer in land and building asset class. Today we are starting session 3 of chapter laws related to real estate, and we will learn Transfer of Property Act 1882. In session 1 and 2, we have learned section 3 to 53A of Transfer of Property Act. Also, we learned mortgage exchange. Today, we are starting session 3. We will learn gift, charge, and lease of immovable properties. Let us start from lease, from section 105 to 117. Regarding lease, type of lease and kind of lease, we have already learned valuation of real estate. Balance portion we will learn in Transfer and Property Act. In section 105, lease defined. A lease of immovable property is a transfer of a right to enjoy such property made for a certain time, express or implied, or in perpetuity, in consideration of a price paid for promise or a money, a share of crops, service, or any other thing of value to be rendered periodically or specified occasion to the transferor by the transferee who accept the transfer on such terms. In lease 4, these are the main terms: lesser, lease, lessee, primum, and rent defined. The transferor who grants the lease is called lessor. The transferee who receives the lease is called the lessee. The price paid for the lease is referred to as a primum. The money, share, service, or any other things provided in return is known as the rent. Section 106, duration of certain lease in absence of written contract or local uses. Lease for agricultural or manufacturing purpose. This lease for agricultural and manufacturing purpose will run from year to year. Also, if you want to vacate your land, agricultural land, minimum 6 months notice period is required, because someone at crop has done, and then fruit make will come in after 4 to 5 months. So lease that can be terminated before, not before a 6 month. Especially agriculture and manufacturing lease, deemed to be a lease from year to year. Termination can be terminated by either the lessor or lessee with 6 month notice. Lease for other purpose, deemed to be a lease from month to month. Termination can be terminated by either the lessor or lessee within 15-day notice. Remember, as per TPI Code Act 1882, for housing lease month to month, 15-day notice is sufficient. Sometime MCQ is coming: 15 days, 30 days, 45 days, 60 days. Correct answer is 15 days. Maximum candidate right 30 days. Lease how made? Register instrument requirement. Already we learned in session 1 what is the registered instrument. A lease of immovable property from year to year or for a term exceeding 1 year, or reserving a yearly rent, must be made by registered instrument. Other lease, Lease not meeting the above criteria may be made either by registered instrument or by oral agreement accompanied by delivery of possession. Execution of registered instrument. A registered lease must be executed by both the lessor and lessee. State government notification. State government rise notification especially for the agriculture lease. The state government may allow certain lease to be made by unregistered instrument or oral agreement without delivery of possession through notification in the official gazette. It depends state to state, especially on the agriculture land. Now section 108, rights and liability of lessor and lessee. Right and liability of the lessor. When lessor giving lease to lessee, so both lessor and lessee having some rights and liability has to follow it. Right and liability of the lessor. Disclosure of the defect. The lessor must inform the lessee of any material defect in the property known to the lessor but unknown to the lessee. So lessor has informed what is the defect in the property to lessee. Possession. The lessor must provide the lessee with possession of the property upon request. So lessor give the possession to lessee. Quiet enjoyment. The lessor guaranteed the lessee uninterrupted enjoyment of the property, provided the lessee pay rent and fulfill lease obligation. If lessee is paying the rent and fulfill all the agreement, then lessee can enjoy the property. No disturbance to be given to lessee. Right and liability of the lessee. Accession and attachment. Lessee is entitled to addition made during the lease. He can add something and can remove attachment, restoring the property to its original condition. When lease is terminated, he has to give his property in same condition, or otherwise terms of the lease agreement. Destruction of property. Lease may be voided if the property is destroyed by force majeure, not due to lessee fault. If due to force measure something loss happen to the property, then lease may be voided. Repair and payment. Lessee can undertake repair. First, lessee to inform to lessor that this repair is required. If repair is not being by lessor in a specified time period, say 1 month and 2 months, then lessee can do the repair, and whatever expenses is there, he can deduct from the rent. Crops. Lessee retained right to crops sown during the lease and access to harvest them after termination. यदि फसल लगाई गई है तो लीज टर्मिनेट हो जाती है, तो फसल का फाइनल प्रोडक्ट निकलना बाकी है, तो लेसी लीज टर्मिनेशन होने के बाद भी आके फसल काट के अपना फाइनल प्रोडक्ट ले जा सकता है. ट्रांसफर ऑफ इंटरेस्ट. लेसी में ट्रांसफर देयर इंटरेस्ट सब्जेक्ट टू लीज टर्म्स एंड लायबिलिटी. Disclosure and notification. Lessee must inform the lessor of the significant fact affecting the property and notify of legal proceeding. So lessee has to inform to lessor what is the problem in the property. Rent and maintenance. Lessee must pay rent on time, maintain the property and return in good condition at termination. Use and alteration. Lessee may use the property reasonably without altering its intent to use. Permanent alteration need the lesser constant. So if lessee is doing any permanent alteration, then he has to take the lesser permission, lesser consent, except for agriculture. Restoration of possession. Lessee must return the property to the lessor upon lease termination. These are the lessee liability, rights and liabilities. Section 109. Right of lessor transferee. This is a lessor transferee, means lessor has sold something to new lessor. The transferee, new lessor of lease property acquire all right of the original lessor. The original lessor remain reasonable for lease obligation. यदि लेसर ने अपनी प्रॉपर्टी दूसरे लेसर को बेची है और उसमें कोई किराएदार रह रहा है, तो नया लेसर होगा वो रेस्पॉन्सिबल रहेगा लीज ऑब्लिगेशन अनलेस द लीज lessee choose to hold the transferee. Section 110. Exclusion of day when lease began. If a lease specify a start date, that day is excluded when calculating the lease term. If no start date is mentioned, the lease began from date of the creation of document, registered document. Determination of lease. A lease of immovable property ends due to expiration of the lease term, conditional limitation or termination of the lesser interest, merger of lessee and lesser interest in one person, merger of lessee and lesser interest in one person, express or implied surrender by mutual agreement, forfeiture due to breach of insolvency, notice of termination by lesser or lessee. Section 112. Waiver of forfeiture. Forfeiture under Section 11G can be waived if the lessor accepts rent after forfeiture or act in a way that shall intend to continue the lease provided they are aware of the forfeiture. Accepting rent after filing on eviction suit does not constitute a waiver. For Hindi viewers, you go through this Hindi English mixed language. सेक्शन 11G के तहत फोर फीचर को वेव किया जा सकता है अगर लेसर फोर फीचर के बाद रेंट एक्सेप्ट करता है या एक्ट करता है जो ये दिखाया है कि वह लीज को जारी रखना चाहता है, ऐसा उसे फोर फीचर की जानकारी हो। इवैक्यूएशन सूट फाइल करने के बाद रेंट एक्सेप्ट करना वेवियर नहीं माना जाएगा। आप एक तरफ से नोटिस देते हैं कि मकान खाली कीजिए और रेंट भी एक्सेप्ट करते हैं, तो ये मकान खाली करना नहीं माना जाएगा। Waiver of the notice to quit. A notice to quit which is given under section 1111 clause H can be waived if the person who issue the notice act in way that show an intention continue the lease. This can happen with either express or implied. So many times this term is came express and implied. What is the meaning? Yeah, I think you have learned in law general. Express and implied. इसको सिंपल हिंदी भाषा में मैं समझाऊं। आप किसी काम के लिए घर से बाहर जा रहे हैं, तो आप अपनी मदर को बोलेंगे कि मैं ये काम करने इधर जा रहा हूँ, वो काम करने इधर जा रहा हूँ। आपकी मदर बोलेगी ठीक है बेटा, ठीक है, आप ये काम करके शाम को आ जाओ घर पे। दिस इज द एक्सप्रेस। आपको मदर ने कॉन्स्टेंट दे दिया एक्सप्रेस। और यदि आप मदर को बोलते हैं कि मैं ये काम करने जा रहा हूँ, वो काम करके शाम को मैं इस टाइम पे आ जाऊंगा, आपकी मदर कुछ नहीं बोली, तो ये एक तरह का इम्पाइल्ड कांस्टेंट है। Okay, you can go learn in English. Express consent. This is when the person directly agree to waive the notice. Impiled constant. This occur when the person action indicate that they are treating the lease as still valid despite the notice. आपने नोटिस दे दिया, उसको खाली करने के लिए नहीं बोला, चुपचाप बैठे रहे, उसने भी आपको वर्बली कुछ बोला, आप उस पर भी चुप रहे, तो इम्पाइल्ड कांस्टेंट है, कंस्टेंट है, इम्पाइल्ड कंस्टेंट है. For example, if the lessor accept rent after the notice to quit as expired or take any action showing they want the lease to continue, the notice to quit is considered waived. Example, this example is given in the Transfer and Property Act 1882. You download this Transfer and Property Act from indiancourts.nic.in. You can go through it. Acceptance of rent after expiry. A. The lessor give B. The lease. A notice to quit to lease property. After the notice expire, B. Pay rent that has become due and A is accept the rent. In this case, A acceptance of rent implies they are treating the lease is continue. So the notice quit is waived. Second notice. A. The lessor give B. B is the lessee a notice to quit the property. After the notice expire, B continue to occupy the property. A then give B a second notice to quit. Since A is giving a second notice, the first notice is waived, implying that A is still treating the lease is subsisting. Relief against forfeiture for non-payment of rent, Section 114. If forfeiture occurred due to non-payment of rent and the lessor sue for eviction, the lessee can avoid eviction by paying the rent due with the interest and legal cost at the hearing. If security for payment is provided, the court may allow the lease to continue as if forfeiture had not occurred. Okay. Relief against forfeiture for other breaches. For forfeiture due to the breach of an expired condition that non-payment of rent, lessor must serve a notice specifying the breach and allow the lessee reasonable time to remedy it. Only if the breach is not remedied within a reasonable period can the lessor proceed with eviction. This section does not apply to breaches related to assignment, under letting, or disposal of lease property. Effect of surrender and forfeiture on under lease. Surrender of lease does not affect under lease provided they have terms and conditions similar to the original lease except for rent. The under lessee will pay rent to the lessor. Forfeiture of lease cancel under lease unless forfeiture was obtained fraudulently or relief under section 114 is granted. Effect of holding over. If a lessee or under lessee remain in the position after the lease ends and lessor accept rent, this lease is renewed from year to year or from month to month based on the original lease purpose. Illustration. These are from Transparent Property Act. A let a house to B for 5 years. B underlet the house to C at the monthly rent of ₹100. The 5 years expire, but C continue in possession of the house and pay the rent to A. C is the lease is renewed from month to month. Hope this example is clear. A ने बी को हाउस दिया 5 ईयर के लिए लीज पे, बी ने सी को दिया सब लीज पे. After 5 years, A और बी का कॉन्ट्रैक्ट क्लोज हो गया, लेसी बी इज द लेसी, उस हाउस में सी रह रहा है और सी ए को रेंट दे रहा है, ए उससे एग्री है, तो सी का लीज रिन्यू हो जाएगा फ्रॉम मंथ टू मंथ. In same case, other example, A lets a farm to B for the life of C. C die, but B continue in the position with A assent. B lease is renewed from year to year. Next point, exemption of lease for agriculture purpose. In Transport and Property Act, some exemption is given for agricultural land because many times state government as per state condition and village condition, they can raise the notification and official gazettes. The provision of this chapter do not apply to lease made for agriculture purpose. However, the state government has the authority to declare via notification in the official gazettes that all or any of the provision of this chapter will apply to such lease. This declaration can be made for all or specific agricultural lease and may include or subject to local law currently in force. This our lease chapter is over. Type of lease and kind of lease already we have learned. Valuation of real estate. Please go through it. Now one small topic, charge, section 100. A charge on immovable property is when that property is used as security for the payment of money but does not involve a transfer of ownership like in mortgage. I will explain with the example. The person who is out the money has a charge on the property, meaning they can claim the money from if needed. This charge is same some like a simple mortgage. They are giving some guarantee and taking the some money. Uh, First learn this example. Mr. A agreed to lend Mr. B rupees 5 lakhs. Mr. B offer his property as a security for the loan. A written agreement is made between A and Mr. B stating that if B does not repay the loan, Mr. A has right to claim the 5 lakhs from the house. A एग्री हुआ बी को 5 लाख रुपए देने के लिए और बी ने कहा कि मेरे पास ये मकान है, मकान का ट्रांसफर नहीं किया, एग्रीमेंट कर लिया कि यदि वो मकान वो 5 लाख रिटर्न नहीं करेगा तो वो 5 लाख मकान में से बेच के या बेच के वो 5 लाख रुपए ले सकता है. दिस इज कॉल्ड ए चार्ज. A charge on immovable property is when that property is used as security for payment of money. Here सिक्योरिटी ऑफ मनी के लिए वो प्रॉपर्टी यूज कर रहा है कि आप मेरे को 5 लाख दीजिए, ये मेरा मकान है और मैं आपको 5 लाख रिटर्न कर दूंगा, नहीं करेगा तो ये मकान आपका रहेगा या इसको सेल करके मकान से 5 लाख ले लेने का. But it does not involve a transfer of ownership like a mortgage. Mortgage में क्या, you are transferring in ownership कि आपने ओनरशिप ट्रांसफर कर दी, पैसा नहीं दिया, ओनरशिप अब्सोल्यूट हो जाएगी. या यूज फॉर मोर्टगेज, रेंट एंड प्रॉफिट आपको मिलता रहेगा. सेल डीट आपने जमा कर दी ओरिजिनल, तो सेल डीट के अगेंस्ट में वो बैंक सेल करके प्रॉपर्टी को थ्रू कोर्ट, अभी तो सरफासी एक्ट है, थ्रू सरफासी एक्ट वो सेल कर सकता है बैंक. इसी तरह का एक चार्ज होता है। ये एक तरह से सिंपल मॉर्गेज भी इसको बोला जा सकता है, जस्ट लाइक ए सिंपल मॉर्गेज। पर वो प्रॉपर्टी के अगेंस्ट में प्रॉपर्टी दिखा के पैसा उधारी लिया, और Mr. A and Mr. B stating that if he does not repay the loan, Mr. A has right to claim the rupee 5 lakhs from the above house. This is in syllabus, so I am going charge section 100. But I have seen one and two times MCQ 1 is coming. 1 mark. What is the charge? Immovable property must be involved. The charge can be for immovable property. A property acts as a security for payment but does not transfer ownership. A charge can be created through an agreement between parties, like a contract or will, or by law, such as unpaid purchase money. To enforce a charge, the person with the charge must file a lawsuit in the court. Charge cannot be enforced against property that has been sold or transferred without the new owner being notified about the charge beforehand. Okay, now next topic is gifts, section 122 to 129 of the Transfer of Property Act 1882. Section 122, definition of gift. A gift is the voluntary transfer of existing movable or immovable property made by one person, the donor, to another person, the donee, without any consideration. The gift must be accepted by the donee or in their behalf. Key points. So, without consideration, gift can be given. Property you can give to your relative without taking any money. Voluntary. The donor action must be voluntary. Existing property. The gift must involve existing property, not future property. Gift, whatever you are having and existing in your hand, in your name, only that property you can give the gift. You cannot give a gift. You will get the house after 3 years, and after 3 years, this house will be gifted to this one. Acceptance. The gift must be accepted during the donor lifetime while they are capable of giving. If the donee dies before acceptance, the gift become void. The gift may be accepted by donee in donor lifetime. If anyone, if a donee is die, then gift become a void. Section 123, transfer of gift. Immovable property. A gift of immovable property must be made through a registered instrument signed by donor and attached by at least two witnesses. Movable property. A gift of movable property can be made either through a registered instrument or by delivery of the property, similar to how goods are delivered in a sale. ठीक है, मूवेबल प्रॉपर्टी, आपका स्कूटर कार है तो आप गिफ्ट में दूसरे को दे सकते हैं। और यदि इमूवेबल प्रॉपर्टी है, देन यू हैव टू गो with registered instrument only. Movable property में you can go with registered instrument or directly can give the delivery. Section 124, gift of existing and future property. If a gift include both existing property and future property, the gift is valid only for the existing property. The gift is void as to the future property. फ्यूचर प्रॉपर्टी के लिए आप गिफ्ट नहीं दे सकते हो। जब आपके पास प्रॉपर्टी है आ जाएगी, उसके बाद ही आप गिफ्ट कर सकते हो। सेक्शन 125, गिफ्ट टू मल्टीपल डोनीज. If gift is made to do two or more person and one of them does not accept it, the gift is void as to the interest that person would have taken if they had accepted. One number MCQ came this from 3 lines only. If there are 3 donee, one is not accepting, what will happen to the gift? That gift become a void for all. Section 126, suspension and revocation of gift. A gift can be suspended or revoked under certain conditions. Revocation by agreement. If the donor and donee agree that the gift will be revoked upon a specific event that does not depend on the donor wills, the revocation is valid. Revocation by donor wills. A gift cannot be revoked solely at the donor discretion. A gift also be revoked if it could have been resigned as a contract, except for lack of consideration. I will explain this by these 2 examples. Example 1. A gift a field to B, reserving the right to take back the field if B die without descendant before A. B die without descendant during a lifetime. A may take back the field. What is meaning descendant? Descendant में उत्तराधिकारी, लीगल हेयर. बी डाई हो गया, उसके कोई उत्तराधिकारी लीगल हेयर नहीं है. तो ए ने कंडीशन रखी थी बी को जब ये गिफ्ट दिया था कि आपके पास ये फील्ड गिफ्ट है, और बी ने उसको एक्सेप्ट कर लिया, और किंतु कंडीशन थी कि यदि बी का कोई उत्तराधिकारी नहीं रहेगा तो ये सारा का सारा फील्ड जमीन वापस ए के पास चली जाएगी. तो इस केस में सेम है, बी मर जाता है ड्यूरिंग ए का लाइफ टाइम में, ए के जिंदा रहते हुए. नाउ ए मे टेक द बैक द फील्ड, क्योंकि बी का कोई उत्तराधिकारी नहीं है. A gifts a field to B, reserving the right to take back the field if B die without descendant. Means कोई उत्तराधिकारी before A. B die without descendant during A lifetime. A may take back the field. Second example. A gift rupees 1 lakh to B, reserving the right to take back rupees 10,000. The gift remained valid for rupees 90,000, but A returned rupees 10,000. Hope both examples are clear. Section 127, onerous gift. Onerous gifts are those where part of the gift is burdened with an obligation. If the gift involves several things, one of which is burden, the donee must accept the entire gift or refuse it completely. यदि डोनर के पास 5 प्रॉपर्टी हैं, पांचों प्रॉपर्टी वो डोनी को दान दे रहा है, और एक प्रॉपर्टी में बैंक का कर्जा चुकाना है 10 लाख रुपए, या XYZ कोई भी ऑब्लिगेशन है, तो डोनी को वो पांचों गिफ्ट एक्सेप्ट कर रहा है तो वो एक्सेप्ट माना जाएगा. यदि एक भी गिफ्ट वो मकान एक्सेप्ट नहीं करता है तो वो पांचों एक्सेप्ट नहीं माने जाएंगे. तो वो एक मकान के ऊपर जो बर्डन है उसको भी एक्सेप्ट करना है. लेट्स अगेन गो एग्जांपल. A give B shares in prosperous company X and a sterling company Y. B can refuse the share in Y but cannot accept share in X unless they also accept share in Y. Clear? A give B a lease for a house with a high rent. and also a sum of money in a separate transaction. B. Refuse the lease but keep the money. This is not acceptable. He has to accept both the things. Okay, section 128, universal gift. A universal donee is someone who receive all of the donor property. In such case, the donee become a personally liable for all debt and liability of the donor at the time of the gift, up to the extent of the value of the gifted property. ठीक है, यदि डोनर अपना सारा संपत्ति डोनी को दे देता है, डोनी वो सब एक्सेप्ट कर लेता है, तो डोनर के ऊपर कुछ उधारी डेट लाइबिलिटी है, तो वो फिर डोनी की हो जाएंगी अप टू वैल्यू ऑफ द गिफ्टेड प्रॉपर्टी. Summary. A gift is a voluntary transfer of property without consideration, either movable or immovable. Immovable property must be transferred via a registered instrument, while movable property can be transferred either via a registered instrument or delivery. Their gift can be revoked or suspended under specific condition, and onerous gift impose obligation on the donee. A universal donee inherits the donor's entire property and become liable for donor debt and liabilities also. The chapter exclude donation made in contemplation of death and gift under Mohammedan law. This is a separate rule, Mohammedan law. We will learn in separate session. Next, Doctrine of Election. This is section 35 of the TPI Act 1882. The doctrine of election apply when a person, the transferor, attempt to transfer property they do not own, and as part of same transaction grants a benefit to actual owner of the property. The owner must choose elect either to accept the transfer or dissent from the transfer, accept the transfer and keep the benefit, dissent from the transfer, in which case they forfeit the benefit. Let's understand with example. The farm of Sultanpur worth rupees 800 belongs to C. This farmland belongs to C. E throw a gift deed, profess to transfer the farm to B and offer 10,000 to C in the same deed. Actually, property owner is the C. Now A throw gift deed propose to B to sell this and asking C to take the benefit of 1,000 rupees. If C elect to keep the farm, then he forfeit the rupees 1,000 rupees. If C accept the rupees 1,000, then they must transfer the farm to B. Second scenario. If A die before C make an election, A representative must pay rupees 800 to B out of rupees 1,000 meant for C. This is called a doctrine for election. Sometime one number MCQ is coming. Key rules. If the transferor does not own the property, the owner must make a choice. Here transferor is the A in the example. He having no property. If the owner accept the benefit, it is assumed they confirm the transfer. If the owner enjoy the benefit for over 2 years without dissent, it presumed they confirm the transfer. If the owner has a disability, the election is postponed until the disability ends or competent authority makes the election. Additional example. He transfer an estate belongs to C to B. In the same deed, give a coal mine to C. C used the coal mine and exhaust it. By doing so, C confirmed the transfer of the estate to B. This is the example of Doctrine of Election, section 35. Now you further move. Transfer by ostensible owner. What is meaning ostensible owner? Benami sampatti. Benami owner. An ostensible owner is a person who appears to be the owner of the property with all outward indication of ownership but is not the real owner. प्रॉपर्टी सब उसके नाम से रहेगी पर एक्चुअल में प्रॉपर्टी को खरीदने के लिए पैसा और किसी ने दिया हुआ होगा. Key points. The ostensible owner holds the property in their name but does not hold the actual ownership rights. Ownership right lie with another person, often under a benami transaction, property acquired in one person's name but paid for by another. Benami Transaction Act in 1988, the person in whose name the property is held is considered the real owner unless proved otherwise under the provision of the Act. In 1988 Act, the person whose name in the property held is considered is the real owner unless proved otherwise under the provision of the Act. Condition for valid transfer by ostensible owner, section 41. The ostensible owner must transfer the property with the consent of the actual owner. The transfer must be for consideration. The transferee must take reasonable care to verify whether the ostensible owner has the authority to transfer the property, act in good faith during the transaction. Illustration. Example. X is the actual owner of property, but allow Y to act as the ostensible owner with the full authority. Y sell the property to Z for a fair price. Z, taking reasonable care and believing in good faith that Y is the authorized to sell the property, complete the purchase. X cannot challenge the sale as it fulfills the requirement of section 41. Next, Doctrine of Estoppel. This doctrine applies to transfer made by an unauthorized person who later acquire ownership of the property. Fraudulent or erroneous transfer. This transfer falsely claims ownership of property and transfer it for consideration. Subsequent acquisition of ownership. If the transferor later becomes the owner of the property and the transferee has not resigned the contract, the transfer is bound to complete the transfer. But this type of example, if father has made a will कि after his death, his son will be the owner of this property. Uh, uh, but before father die, son is selling the property. Actually, he is not a owner. That type case is coming, Doctrine of Estoppel. The transfer falsely claims ownership of property and transfer it for his consideration. If after transferring the property by any way, he is not a owner of the property, in between that person die who has done the will and he has not cancelled the contract, then contract will be live. He cannot take the property back. If the transfer later become the owner of the property, when he will become the owner of property, when his father will die, and the transferee has not resigned the contract, and transferee has not resigned the contract, the transferor is bound to complete the transfer. Rights of transferee. This transferee can claim the property once the transfer acquire ownership. Okay, transferor can, once his father will die and transferor become the owner, he transferee claim the ownership. A shall field Z to C, falsely claiming it belongs to him. Later, A inherits Z upon B death. Since C has not resigned the contract, he can demand Z from A under section 43. Okay, hope this is the clear. Now, two type of tenancy. We have learned also valuation of real estate. Again, here we are learning joint tenancy. Joint tenancy occur when two or more people own equal share of the property. This is the important in joint tenancy, equal share of the property. If two owner is there, two joint tenants joint is there, then both 50-50%. Unity of title and possession. All joint tenants have equal right and possession of the property because they are having equal share. Right of survivorship. When one joint tenant die, the share automatically pass to the surviving co-owners, not their legal heirs. This is 50%, this is the 50%. Second joint owner, if one is die, then this 50% will transfer to second joint owner. 200% he will become. Is not transferred to his legal heir. Tenancy in common. Tenancy in common occur when two or more people own a property but their share may or may not be equal. In tenancy common, it is not necessary all having the equal shares. If 3%, one can be 25, second can be 35, and third can be 40%. The share or percentage of property may be different. And here unity of possession. In earlier case, unity of title and possession. All tenants in common have equal right to use and possess the entire property irrespective of their ownership shares. No right of survivorship. Upon the death of one co-owner, their share does not pass to the other co-owner. Instead, it goes to their legal heir of representative. In this type of tenancy, tenancy in common, if two joint is there, this is 50%, this is the 50%. If one person is die, so his share will not go to second one. His share will go to his legal heir. Let us understand with this diagram also. Joint tenancy, tenancy in common. Joint tenancy, three person, A, B, C, all having equal share, 33.33% ownership. And tenancy in common, one having 20% share, second having 30% share, and third one having 50% share. This can be possible in tenancy in common. Joint tenancy, equal share. If A passes away, if A gone to God house, then his share will pass away. Both will become 50% and 50%. In this case, tenancy in common, if A is pass away, this gone to God house. Here, this gone God house. Then his share will go to A beneficiary, his legal heir, and B and C having the same share. This is the tenancy in common. Sometime one number MCQ is coming. And again, you can understand by this in tabular form. Ownership share, equal share for all co-owners. Tenancy in common share can be equal or unequal. Unity of title. Require unity of title, interest and possession. Require only unity of possession. Here title and possession. Right of survivorship, I have explained. Transferability, I have explained. Common uses, often used by spouse or close family member. Husband and wife can use this joint tenancy. Common in business arrangement or investment. Now, next point is Doctrine of Lis Pendens. Section 52 of the Transfer of Property Act. The doctrine of Lis Pendens means the property subject to a pending lawsuit. If there is a pending lawsuit in court case, cannot be transferred or altered during the litigation without the court approval. Lis pendens refer to the time during which a legal action is pending. Lis pendens means legal action is pending and involve the property. Effect of lis pendens. During this time, any transfer or change in the title of property is subject to the outcome of the pending litigation. If a person transfers the property during the pendency to suit, the transfer will be null and void if the court rules in favor of the original claimant. With example, learn. If Mr. A is suing Mr. B over ownership of piece of land, and during the lawsuit, Mr. B tried to sell the land to Mr. C, the sale of Mr. C would be subject to court final decision in the lawsuit. If A wins, the transfer of C would be invalid. So, my dear friends, Transparent Property Act is completed. We have completed complete Transparent Property Act in 3 sessions as per our plan, session 1, session 2 and session 3. In session 4, we will learn land acquisition and silent feature of real estate, that is Regulation and Development Act 2016, known as RERA, Regulating Authority established under Act. This we will learn in session 4. Session 5, session 6, this chapter will our complete. Okay, before leaving the video, please do not forget to subscribe the channel and hit the notification bell. And I am also planning one mock-up test of 100 numbers in same way fashion. Mock-up test will be there as per IBBI examination fashion. Whatever number allocated by IBBI exam of each subject, the same subject, same number MCQ will come in the mock-up test on 24th November. Be ready and try to give this mock-up test, and I will give answer with explanation. Thank you.